Okay, I'm going to do another video. I'm going to have trouble with these because I did so much of what I did as posts and articles, and people today want to see a video, and I need more people to see it because I've got an idea how we can maybe, you know, put something together where we can pay or help more people pay for what they're doing. I know that a lot of people have fought for this for a long time. And am I doing it to make money? No. Would I like to at least stay even? Yeah. Is that possible? No, not like we do it, but something's possible here. I've been looking at YouTube really hard, and I feel like we can come up with a plan and maybe join some people together instead of everybody doing it on their own. So anyway, what I'm going to do is I'm going to start here as if you have just sent me that detailed form I want to see that helps me decide what you know and what you don't know, which keeps our conversation shorter because the more time we spend and you telling me about all the bad guys that did all these bad things that are the same things that happen to everybody, but just to different levels. Some people, yeah, got it worse than others, and that's true. So, what if all this thinking you're doing, all this research you've done, and you're looking for the statute or the law or the magic bullet that can get you out of this, and it just isn't working? And if you call me, you're going to just almost have to tell me all the mean things that happened, and I'm going to tell you that they didn't happen in a court case. They happened in a fraudulent imposter court case, because that's really what happened. The founding fathers wrote the Constitution. The Constitution's the only law you can depend on, because the other laws are still there, and we're losing, and we lose a lot. I've won 9 times. 3 of them are just recently, the last 70 days. And I did it exactly the same way that I'd been thinking for 14 years, only I was thinking it and then adding a little at a time, because I had to get over my disbelief of something. I couldn't believe that the courts were the problem. It just didn't make sense to me. I couldn't believe that my government was the problem. That also did not make sense to me. So, what if your wrongful foreclosure was already void, but you were unaware of this fact? And I'm going to tell you that's what I think is true of mine, and it's wasted. I was middle-aged, and now I got old. I got old this year, and I didn't see it coming. I didn't plan on it, and I certainly was fighting it. And I resent that as much as anything. The waste of time that people that just want a boat and a limousine and hookers down on the street at 2 p.m., and they found a way to steal things without looking a family in their eyes, and none of us, I can tell you that I know the law as well as anybody I know, and I mean anybody that anybody, any lawyer, and I wasn't prepared for crime. I'm perfectly prepared. I'm an expert, I would say, at contracts and real estate and loans. And that's not what we've had here. So what if you're wrongful foreclosure, because that's what you think it is? What if it was already void? You're trying to make it void or get it void, and you're trying to tell the judge, and you're trying to tell anyone to listen, and you're trying to find what motion you send in that will void it. And it probably is. I get letters a lot now. I started this and it picked up, and there's another spike in foreclosures right now. And that's when I get more calls. And then there's these people that have been in court for years and years, that they have held these guys off. And maybe it's disinterest on the part of the guys. Maybe there aren't as many of them sometimes, but it's basically the same people. Ocwen was the servicer that started this. They helped invent MERS. MERS never, I didn't even know they were still, I haven't done anything with this like for 4 years. I simply ran out of money, ran out of cash. I got property and I'm down at Lake of the Ozarks, and I think I can make enough money to get mine into court and maybe do something big enough to help everybody. But it'd be better if we had some way to fund these and we didn't have to look to anyone else. And, I did it for so long, 14 years I've been doing it, um, because I did get money from people, especially at the beginning before they just were worn out. But it wasn't enough to do it because we were doing it the hard way. We were trying to do like I've just said. So I read these long borrower letters trying to tell me, what they'd done to prove over and over that the foreclosing party didn't exist or didn't have the right to foreclose. By the way, there is no right to foreclose, no such thing, and that's important. You have to have the right to collect money from someone, and the only reason that you could have for someone to want to collect money from you is if they had given you any money at closing, or if they had purchased your note with money, which is called consideration legal. So they had to pay, in order to have your note, they had to pay consideration. But that's not how it's being done. I'm going to tell you right now that you're going to tell me that there's an assignment of your loan here, an assignment there. Or you'll even say it's an assignment of a mortgage, or an assignment of a deed of trust, or an assignment of a security deed, or an assignment of a trust deed, which are all the same thing. They are all four of those are the agreement. It's the security instrument, what's called. You've got the note, that's the essential instrument, and you have the security instrument, which is called a mortgage in most law, because that's what it should be. These non-judicial foreclosures, like in my state, Missouri, they're just starting to change some things really fast in the last few years because something's happened even about jury trial. In Missouri, you couldn't fight eviction. You could fight foreclosure, you can't fight eviction. So they say, well, it's constitutional to do a non-judicial foreclosure, to go sell your house out in the yard by the courthouse because you can't go in because it's non-judicial. That's why they have them outside. And the sale, it instantly ruins your credit. Then you find out that you have the right to get your house back, and if you leave it, you're never going to come back. It's too hard, And by the way, I'm the only person that I've ever dealt with. I've had over 150 families in court, state and federal, and won 9 times. Each of the first 7 were spread over several years, and basically I won by doing exactly what I'm doing now, only I didn't have it refined, and so I'd find some little thing to pick at that was really the bad guys were afraid of. And then I thought, well, if that's the case, then how's this even happening? Well, it's the judge, because that's the only person in the room that's not uncomfortable. And all the information is going into the judge's chair, and it's stopping, and all he's doing is not enforcing the laws. The laws aren't gone. He's just not enforcing them. Anyway, so, can I imagine how you feel? Yeah. Mine's the worst I've ever seen. It's the worst thing I've ever seen. $3.5 million of it, I didn't owe any money, and never owed any money. Paid cash for investment property. It shouldn't be that hard, should it? The courts just seem crazy. But what if the court is only incompetent? And what if your judge is just a no-talent judge guy, and somebody offered him so much money he couldn't turn it down, or he got in his head that you were a borrower and you need to pay for your house? I've heard judges say that, well, you owed somebody, you might as well owe Wells Fargo. No, there's no right to foreclose, and there is only the right to collect. And if the judge gives your house to Wells Fargo, but you actually owe Bank of America, two bad guys, U.S. Bank, the worst. If he gives your house to someone and you still owe someone else, and you do because the guy that he gave the house to didn't have the rights, then you have to pay for your house again whenever the real lender comes. Now, you're never going to see your real lender. None of us knew that right away, did we? Anyway, it shouldn't be that hard. And the judge won't learn anything, even if you get him in beat up on him because all of the other judge guys, they're going to protect him from you. And then he'll protect them also. That's what is happening. Nobody's going to learn anything, and judges are doing it, and they don't get caught because you just saw it at the Supreme Court. This is, by the way, the best time we could ever, if you have to work on your house, this is the time to do it, because look at the Supreme Court. No oversight, no way to complain about them, no one to go to, and so they're bribed and stealing and corrupt. And they have agendas. They're not supposed to have any agenda at all. What agenda is the judge's agenda? Is just to apply the law, due process, and due process is what we're talking about. Anyway, so now I'm going to tell you, exactly what I would say had you written me and filled out the detailed form. I've been exactly where you are. I've had as many as 14 families depend on me and in their house, and they gave it to me. And my wife, right by my side, my wife of 22 years, ended up with PTSD, and I suppose I probably have it. Why would I go check? Because how could I not have it? If nothing in your case has ever really happened, okay? As I said, this started out with me saying, well, if your house is already involved, but what if nothing in your case has ever really happened? What if there was no case from the beginning and there wasn't? The basic of all laws is called cases and controversies. It's a body of law, contract law, is that the framers didn't want us to become a litigious society. They didn't want everyone suing everybody at the drop of a hat. That wasn't what they wanted at all. And so they made it difficult to take someone to court. So just because this servicer who said that he had the rights that he got by the assignment of your mortgage or deed of trust, which you can't do it. It is nothing but, it doesn't have anything to do with the money, the debt. And by the way, that's what it is. It's not about the note. It's about the debt. And it's the balance of the debt. When you got a loan, let's say it was for $200,000, the next day it was different. It had gone up a little bit because you owed some interest. Then when the month was out, you paid something, most of it was interest, but you paid something down. So it changed all the time. It's the balance of the debt. That's all you can ever owe. And if you've had your loan for 17 years, I can tell you, if they tell you that you owe more money than you did when you bought it, that's impossible. It's impossible. And, we're not even going to try to prove that. And we're not going to come back with everything they did to you and they tried to get you out of your house. They got you out of your house, but you're still fighting to get it. I know how you're tired, but it's going to be easier than that now. Because cases and controversy means the judge can only take a case that he's already figured out, that he's already read what your foreclosing party said, and he's seen that they have, or if they have not, so he's going to find out, because I've never seen it done correctly. You're going to find out that they have never complained of suffering an injury. And an injury isn't like a broken arm. An injury just means it could be money, and it could be someone stole your house. That's an injury. There's a lot of injuries. Somebody embezzled from you, your partner did, contract law. So you have to have an injury, and they have to complain of the injury. And then I use this same thing all the time, but like if you have a company and one of your guys you really needed today didn't show up and you called and he said, well, I broke my leg. He's claimed an injury. That's not good enough. They were too smart. The guys that wrote the Constitution, they were too smart for that. So the only way that you can prove, or he can prove that he has an injury in fact. So the complaint that he had a broken leg, that's a complaint of an injury. Injury in fact, that you have to have accompanying that, and I mean with their first filing, the first words that they put into the court have to say that we have suffered an injury in fact. And we've included the evidence, the concrete and particularized evidence. That's bigger than beyond reasonable doubt. concrete and particularized evidence that they've been injured. They also have to prove that injury came at the borrower's hands. The borrower caused the injury, which means they have to prove that they own the debt because they purchased the debt, and the note is evidence of the debt. And the best case for this is Carpenter versus Longden, 1872. I call it, it's about wheat as a currency, which I think is really funny, but I don't explain it now because nobody ever laughs when I say it. Anyway, so in Carpenter versus Longden, the court said that the note is essential. It's the essential instrument. You've got to have it because it's the evidence of the debt, and you can't even figure out the debt if you don't have the note to show the terms. How much money was it? What were the terms? How often are you supposed to pay? What's the interest rate? And also, whenever you do pay, they're supposed to mark it down. Wrote on the note. The note is evidence of the debt, and it's essential. The mortgage, deed of trust, the security instrument, which is that if you pay off the loan, instead of everybody saying, "Oh, it's the right foreclosure," or "It's for foreclosure," it's not for foreclosure. It's just what can be used as collateral, and it's agreement that you made, and it's a house, but it doesn't have to be the house. There doesn't have to even be collateral. If you have $10 million and your son wants to build a house, start a business, and he wants a $1 million loan, and you love your son and you want to watch him do good and you want to watch him have a good life, and he gets in trouble, you're not going to take his house. If you are, then you shouldn't have entered this deal. And if you wanted, then you should have had a security instrument. But you don't have to have a security instrument. The note is the evidence of the debt, so you can at least show that you lost the money. Now you can write it off. But you can't buy the incidental document. You can only buy the essential one. The note is essential, and the mortgage, deed of trust, the security instrument is incidental. And wherever the note goes, there is the mortgage. No one ever signs it. No one ever signed it. I never even heard of it until 2008, probably. Okay, so we're going to talk about the superior laws of the Constitution, and I think it's nearly flawless, but they didn't put in oversight. They made the court independent, and they were just going to do the right thing because they had this great job, and they were the smartest guys, and they were known to be good guys, but absolute power corrupts absolutely, and we're seeing it right now on the news every night. So the framers wanted the people, we were supposed to stay informed and keep an eye on the government. And if we ever saw the government was acting in an autocratic way, like we have been seeing, and I don't care who you're for and who you're not for, if you're taking my advice, listen to it. Because I believe that we've seen the most incredibly stupid, the country polarized. Everybody hates each other because of pretty much one guy that figured out if you tell a lie enough times, half the people believe it. Anyway, so that's the problem. And there's no one stepping up from the courts that there are now. Anyway, so here's what I say is you'll never know who is your lender, who was on your note. Most people can't show me it. They don't even have a copy of the note. That's crazy. The note is everything. Where's the note? And so if the note represents a debt, and the debt is the thing, you owe money, and someone gave you money, you owe it back. And in 1994 in Kansas City, Missouri, Jackson County, Missouri, mostly Kansas City, and then the eastern counties of the metropolitan area, probably 500, 600,000 people. There's 450 in Kansas City, and then the metro is 2 million, but half of that is in Kansas. Anyway, in Jackson County, one county, and including yours, wherever you are, California, Maine, worked in both of those. I've worked in New York, Jersey, worked there, Florida, worked there, California, Texas, just mean sheriffs and mean judges, and they have little empires there. And so anyway, the same things happen to everyone everywhere. And what it is, the judge has the burden. You never had any burden whatsoever to prove that somebody's about to fraud you. I did too. I made the mistakes too. We all thought these guys are going to going to take my house, and I didn't do anything, or at least they should have given me a chance. Well, everybody did when there were 49 people foreclosed in Jackson County, Missouri in 1994. By 2004, it was 300 a month. It went to 600 a month and stayed there for 10 years. And now we're all going back up at the same time again. There are spikes now. Some of you have been fighting the whole time for something, but some of you are new. And, there's no reason for us to do this anymore. So there was no burden for you to say anything, but I don't owe these guys. I don't owe this entity, called SLS, or, I've heard so many of them, and I always go, it's probably the same guys. They get in so much trouble and get in court so many times that they change their name. It's all the same guys. They should get a different name. SLS isn't SLS anymore. In May, they turned into, I don't want to try to think of it right now. I don't remember right now. So anyway, whoever your foreclosing party is, they had to say that they'd suffered an injury in fact and provided concrete and particularized evidence in their filing before the judge could even say that there was a case. Filing a lawsuit doesn't start the lawsuit. Shouldn't even be a number. The judge has to look and see if he's got a genuine dispute so he can arbitrate it. They should be called arbitrators. We shouldn't have called them judges, and we never should have given them those big, high places to sit above us in a room, making us feel like they were somehow important. And the robes, what's that all about? Where do they go? Where do you see a judge go into the restaurant in his robe? By the way, when he does that, he's not a judge, and that's what we're talking about here. When is the judge a judge, and when is he just a citizen? And it has to do with standing. And standing is that you've presented a case that you want to take to court because somebody injured you, and you want the court to redress the injury. These are words that are really a part of it. And I've looked at a gazillion cases. I have never seen it done right. And then these REMIC trusts, like you're in a trust and the trust ends in a year, 2007. And then, so all you see is the mortgage. They show you the assignment of the mortgage, and it went from here, some lender maybe, then to a REMIC trust, and then to somewhere else, another trust. And that's impossible. You can't, the trust laws don't allow it. The SEC wasn't even crooked enough to do that. They deregistered them like within a year because they didn't have any investors. They just took the money, and that's why you'll never know who gave you money. You'll never know who came to your closing. And all this had to be put into the case at the beginning, and all you had to say was, just, And did you owe somebody? Sure. Yes, you did. And should you pay it? Absolutely. And if they come, they'll want to set up payments. They're not going to do a foreclosure. They'll want to do the right thing. And if the judge has done what I'd say he's done, he has not reviewed this is what you should, say, did I ever see this? Did the judge ever send the evidence, concrete and particularized evidence, to show that the person that was trying to foreclose on you actually had money in your note? And the note, it really means in your debt. And the debt is the money that you borrowed in the first place. So did the judge file on your case? And it has to be filed, it has to be written up, and the reasoning behind it would be, they had an injury in fact, and they showed it. I don't even know if I finished the story well. The guy with a broken leg. That's an injury, but it's not an injury in fact. It's a claim, so it's just an injury. So to prove it, the only way you prove if that's an injury in fact, concrete and particularized evidence, would be to take the guy, your employee, to the hospital and make him x-ray his leg through the cast to see if it's broken. That's how it should be, that is a real injury. Now, I don't mean you should really take someone down and x-ray them, but yeah, maybe right now I feel like doing that to people. Anyway, so it's impossible. If you didn't really fund the loan, and nobody did, your note is not, whoever's on your note, that's not who funded it. The money came from Wall Street, came from Merrill Lynch, Bear Stearns, Shearson Lehman, someone like that. And they did so many of them at a time that they lost track of them. And then they bundled them again, and they sold them to investors, and they bundled the same batch up again and sold the same ones to the investors, and that's what rocked the country. And there was no law left to protect from that. The only law we really lost was on Wall Street, and that was in 1999, the Glass-Steagall Act of Finance Act of 1934, put in place after the Great Depression to make sure it never happened again, and it didn't happen again until Bill Clinton, the Democrat, and a Republican Congress voted to repeal it and put nothing back in its place. So no regulation on Wall Street, and that's who's running the country. I've never seen a judge review the claim of an injury in fact with the proof of the evidence, but they're doing it for me now, but they're not doing that. I found a couple of ways for them before they commit the crime. By the way, this crime that they commit is deprivation of civil rights. That's where we were going all along. That cases and controversies is really about standing. Standing means that you have a complaint. Someone says that I was injured, and he proved it, and now you have a case because the other guy says it's not us, but everybody kind of admits there's an injury. But we don't have that kind of plaintiff. It's not the person that loans you the money. They can't prove they did. And that's, I'm ready to finish this now. It's taken me 14 years because I've run out of money 3 or 4 times, and I still always have some property or something, but this costs money, and that's going to be your biggest problem. I'm going to tell you how easy it is, and then we're going to try to figure out, well, how do we do this? And it is easier, it's simpler, and it won't cost as much money. And if you're using an attorney, that was just wasted money. And I've gone through that actually in yesterday's video. So all this has got to be filed in one case, and the people that want you to get out of their house, they never tried to prove, they're not even lying about it. All they say is that you're making a claim for which relief can't be granted. And I don't know if you even ever knew that, but it's in their words against you. And then you're saying, well, look at all this, like I had a forensic audit and I found that they don't know where my note went. Well, I could have told you that without the forensic audit, but you, me, and the forensic audit guy, that's not our burden. It was up to the person that wants you to pay them for your house, although they have no attachment to it. They have no right. And the right they don't have is because they don't own the debt. Actually, I think I can just pretty much throw these down now. There's 30 million people. Yeah, I'd like to say this at this point, whenever I'm telling this particular story or parable or whatever it is I'm trying to tell, is that the estimate is between 20 and 30 million people were wrongfully foreclosed. But if there were 49 foreclosures in Jackson County, Missouri in 1994, and by the year 2001 or 2, there were already 100 to 200 a month. So it's the difference between, say, 1,500 and 49. Something's wrong there, and that's been going on. And if it is 30 million, let's just use that number because no one's ever going to know. Nobody kept track. Don't think MERS did, because they didn't. MERS admits we didn't ever have a nickel in anything. We're just hangers on. We were, I won't even try to explain MERS, but I did find that they're more active. And now Fannie Mae, you have to call Fannie Mae to get the MERS information. So now you have a crook, and the other crook is part of your government. And So what they've done is they have made a claim for which relief cannot be granted by saying they did it non-judicial foreclosure or suing you, saying they're going to foreclose on you, and you're in a judicial situation. They're the same. The way we're going to do this, the way we're going to resolve it, is the same. So standing is what the party trying to foreclose doesn't have, and they have to have, or it stops right there. It doesn't void. If they don't pass that test, if they don't prove that they own the money that was given to you and you owe it back to them, you're never going to say you don't owe it. You're going to say, I want to pay whoever gave it to me. And that won't ever be produced, but at least for sure it's never going to be produced in the court case that you're tied up in now. So if there is no standing for the plaintiff, then the reason the judge had to even look at it, see if they had a case, is because he can't move the court forward unless the argument is solid. The argument that you owe these guys right here money, they had to prove that, or the court has no subject matter jurisdiction. So standing is a component of subject matter jurisdiction. If a judge has no subject matter jurisdiction because there was no standing, and he pushes the case forward at all, if he talks about a motion, he can't, because it didn't meet their story, their case doesn't meet the constitutional, irreducible minimum requirements of standing. If so, they have only one thing they can do. They have to shut down the case and not speak about it to either of the parties, and never again, because it doesn't exist. It is void. Void is void, and void cannot be repaired. Standing found to be deficient cannot be repaired. So the best thing to do, and so the judge commits a crime of deprivation of your civil rights. And we've been listening about civil rights our whole lives. Maybe we disagree on the subject matter or whatever, but there's a lot of civil rights. One of them is due process, that you have to be treated fairly in court, and the judge has to use the law, and he has to use his oath to the Constitution and do the right thing, and he has to obey the constitutional law of cases and controversies. That's absolute. If he does not, well, the law is that a judge cannot deprive anyone of their civil rights. A judge can't do it. It's not allowed. It can't happen. It's impossible. That's how the law treats it. So if he moved the case forward without subject matter jurisdiction because there was no standing, then he wasn't a judge. Okay. Should I pause here for everybody to think about it? If a judge can't do it and someone did it, or it looked like they did it, they were just driving a stolen bus, Subject matter jurisdiction, if there isn't any, then he's not a judge. He's an imposter. That's the only time that you can sue a judge for damages. And you can sue them, and the court can't protect him, the government can't protect him, the DOJ can't protect him. I mean, the law says that he cannot look for protection because he's outside the law of the Constitution, and that means he's at war with the Constitution. Those are the words. He's at war with the Constitution. So, what if your foreclosure is already void and you just aren't aware of it? So, you need to look at it a different way. And I'll do some things for free here that I'll review your case if you'll fill out the form the way I tell you to, so you don't have to talk to me for 5 hours to tell me every fight you fought in your void, non-existent case. Now that's going to be hard for you to take, that you've been treated horribly, shabbily, and the damages are going to be big if we ever get traction, and I've just started getting traction. I've won a case in my area, $2.5 million in damages in the house. And the judge did nothing wrong. In fact, he went to college where I went, and I knew of him. We didn't know each other, and I couldn't say anything because I'm not. By the way, I'm not a lawyer. That's the only good thing that I probably am. I'm not a lawyer. That puts me way up there because I'm not going to play golf with a judge this afternoon, Friday afternoon, and I'm never going to have dinner with him. And he only got to where he is by having dinner with someone else. In Missouri, we vote in the state judges like prom queens. You vote them in popularity. It doesn't mean that they know what to do, and it doesn't mean that they won't take money. And I'm not going to say I can prove anyone took money. I'm just saying that this is bizarre if you really think, and it was always bizarre, and it drove a whole bunch of us mad as hatters. The 10,000 to the 2010 to 2012 class is still fighting it. One of the smartest guys I know just lost his house after 20 years. What? So you need to rethink it, and we need to go back to see what's really been filed in your courthouse and what's really been said, and then think of when we're going to surprise them with it. And if you really have the will to go forward, it's going to be scary, but not really. It's your law. It's like maybe it's an ugly fish, but it's from your lake. So that's the way to care for it, and that's what I'm talking about. And I really probably have repeated myself too much anyway. That's why I write instead of talk. My name is Danny Hammond. I've been doing this for a long time. I'm from a small town in Missouri, not very far from Kansas City, not very far from Lake of the Ozarks, and this is coming to you from Lake of the Ozarks. Look it up, and I don't know, maybe there's a map you can follow to my house. Okay, the information to get a hold of me, there's I don't know that it shows up. It should, but anyway, it's an email, and then also there's a form. If you click on the form, you get it, you fill it out. If you leave blanks, because you don't know, don't fight it. Don't worry about it, because I need to know what you don't know. That way I don't have to explain it to you, or I have to explain it to you. What you do know, I can tell you why that's wrong too, but I have to know what they are, or we'll just talk in circles, because you're going to be upset, and I'm going to tell you that you can't go kill all the lawyers. We can't do it that way. But we can, we are supposed to, it's our duty. In the Constitution, it says our duty. If the government begins to start leaning autocratic, then the citizens have to take it back and put it back like the words. Don't change the Constitution. Throw out the bums that aren't following it, and that's our burden. Anyway, I'm going to try to come up with a way, and I've been watching how you raise money on YouTube today, and it's the only way we can do it, because back in 2012, I wouldn't even ask for a jury trial, because there were too many people that paid for their house and thought that borrowers are trying to get a house for nothing, which it just isn't true. But I mean, how could they believe it? They never saw it, didn't hurt them. And there just was never, you couldn't do GoFundMe or even to get just little bits of money just to keep the core, pumping out lawsuits. And that's the idea, is that they're not hard. You just have to have the will to do the next thing. And the next thing is that you're going to go to your state court, and you're going to tell the judge that he wasn't a judge, and that you're about to take him and sue him. And I've just done that, and it was fun, a lot more fun than you think. And I honestly, it worked out that I could manipulate it to the point where they hadn't done it yet, but they were about to break that law. And you do that by jumping from from state court, where it's a pretend lender against you, and you take it to federal court where it's you against a judge, and you don't have any problem with res judicata, which it's already been ruled on. No problem with that. Anyway, love to have your help. Try to get aboard. I don't want your house. I don't want your money. And I don't want to tell you a bunch of stuff about, oh, here's a pro se class, and you'll be pro se, but you're not going to take a class because, I don't want any money for that. I would just like to help as many people as I can. I think it's a civic duty for all of us. I think voting is a civic duty. I don't care which way you believe. Vote for the crazy guy, but vote. Because I think I think only people that like the crazy guy are going to vote. So I want to be sure that say that. Anyway, so thanks a lot for listening to me. I hope I said something worthwhile. The best thing you can do is get me up to where I make money with the subscribe, like, and notifications, and build that up and join the channel so we can make it into some kind of a powerful force, and maybe raise the money through the advertising on YouTube with me getting enough followers that then I get to that point where you get as much money. And I've watched some guys, I started watching it really close, and I know kind of what to do. I don't know how to put captions on it yet, but I'll do that right away. Anyway, Danny Hammond, nice to meet you if we haven't talked before, and good luck. If you just take the information, go do it yourself and win, good. That's great. Thank you. Bye.